Hello, everybody. My name is Jim Wolverton, and I am the Director of Legal Education here at Kraus Financial Services. I'm starting a new series that I have been thinking about for a long time that I thought would be interesting, and that is to summarize some of the more recent cases that really had an impact in Medicaid planning. And the first one that jumped to my mind when I was thinking about this idea is the Geyen case out of Minnesota. That case was very important for a number of different reasons. And what I've done is I've asked the attorney who actually handled that case from beginning, all the way from setting up the irrevocable trust back in 2011, all the way through the appellate process, and is actually still working on that case today. So he has been gracious enough to join me for a conversation that we had, uh, and really going over what was it like to be involved in that case while it was happening. And so, kind of the purpose of this and my goals for this conversation that you're about to watch were to really get to know the people behind the case, the attorney and the clients. What were they thinking? What was going through their decision-making process? And what was it like to be an attorney who had a case that was denied and then follow that all the way up to the appeals court when we knew that the law was on his side the entire way. Also, he talks a lot about the support he got from the local NALA group there in Minnesota. And it really does just reemphasize that elder law is a much more communal type practice area where we help each other and we try to get the law straight. So if you're getting into this practice area, please start there, working with your colleagues there in the elder law bar in your state through the local NALA chapter. Can't give them enough credit there in Minnesota. So before we get started with my conversation with John, I did want to just do a really high level overview of the Geyen case. And this one, when this one came across my desk, it floored me because there was a statute in Minnesota that you can see by reading the case that really just didn't comport with federal law. And it really stood out as one of those statutes that needed to be challenged in elder law planning, in Medicaid planning specifically there in Minnesota. So, as a quick overview of this case, the Geyen case, I'll try to do a quick overview. Please read the case on your own before you watch the video. It'll help things make a lot more sense. It's actually a very well written case as well. But a quick overview of the case is Dorothy Geyen created two irrevocable trusts in 2011, and John was actually the attorney that prepared those and helped her fund those. Later, she needed long-term care, and through that process, applied for Medicaid benefits. And as I mentioned, in Minnesota, there's a statute on the books that says that an irrevocable trust will be treated like a revocable trust for qualification purposes, which, as many of you probably know, is the opposite of what federal law states in 1396P, that irrevocable trusts should be non-countable resources so long as they pass the any circumstances test to access to those funds. And this Minnesota law has been on the books since 2005, and it just hadn't been challenged or overturned through the courts to that point. And this case was in 2021. So that case has been on the books for over a decade. Dorothy's application was denied primarily due to this rule. The workers there in the Medicaid office saw the statute and denied the application, counted the assets in the irrevocable trust as countable resources. Unfortunately, the facility that Dorothy was living in, they threatened to throw her out if she didn't make payment. And the trustee of the trust, in violation of the terms of the trust, liquidated those trusts to pay for her long-term care. So that's kind of a twist in the case where the state tries to make an argument based around that, and they were ultimately unsuccessful. During the case and during all this appeal process, and pretty early in the process, she passes away. And I thought that was a really interesting decision-making point. So I asked John about that, but they decided to move forward, and John handled that case from, like I said, the beginning all the way through. The fair hearing was ruled in favor of the Medicaid agency, as most fair hearings will be, and then John appealed it up to the district court. And at the district court level, that's where he got his first victory. And the district court ruled against the agency And then the agency then appealed that decision up to the appellate court. And that's the holding that we'll be talking about. In that decision, you'll see there's three issues that, in my mind, kind of rise to the top of the court's holding. The first one is, like I mentioned earlier, is the state's attempt to get this case thrown out because Dorothy passed away during the appellate process. And the court ultimately said that doesn't take away her standing to challenge what happened while she was still alive. And this is a really big deal for attorneys that are doing Medicaid planning and long-term care planning, because a lot of times clients just don't have the time to make it through the lengthy appellate process. So very important victory there on that first point. The second, and obviously really important for any irrevocable trust case, is a trust has to be drafted correctly. It has to limit access directly or indirectly to the principal of that trust for it not to be a countable resource. And so the state challenges that. I don't think there's a very strong argument that this irrevocable trust was drafted correctly, limiting access to that trust. So they prevailed on that issue. And then the grand finale, and probably the most important and impactful for other Minnesota practitioners, and also for other attorneys that are working in states that might have policy or statute on the books that violate federal law, is the federal preemption question. And that's really the one that kind of raised my eyes to this case and got me excited for John and obviously for the Geyen family to get a decision in favor of themselves for the state violating federal statutes and overstepping their bounds, that they can create rules and regulations around the Medicaid program. And this was, like I said, a very monumental case. I know the Minnesota NALA chapter was very excited for this decision once it came through, because they were very helpful in helping John prepare for that. And he does talk about that during our conversation. So hopefully you find this enlightening. And again, I can't thank John enough for his willingness to come on and help me out. And hopefully this is a good use of your time to learn more about what happened behind the case. So thank you so much, and I hope you enjoy our conversation. And today I'm joined by John Waldron, the owner of Waldron Law Offices in Wayzata, Minnesota. John has been kind enough to join me today for a conversation about the case Geyen versus Commissioner of Minnesota Department of Human Services. I've asked John to kind of share what he was going through the decision-making process along the way, the challenges in taking a case like this all the way up to the appellate court level, the support he received throughout that process, and kind of some of the biggest takeaways from taking a case like this up on appeal. So John, why don't you kind of set the stage for us as far as what your practice is like, and then we'll kind of get into the client's situation as we kind of move forward. So why don't you start with, your practice, what was going on when you started working for this family?
Sure. Sure. Thanks, Jim. Right now, my practice is primarily focused in three areas. It's estate planning, probate, and real estate law. I also do some general corporate. And I would say my practice was probably similarly focused at the time when I first met Dorothy Geyen, which was quite a number of years ago.
And how did you meet Dorothy?
So this is kind of unique, but I'll try to make this the short version.
Oh, no, take your time.
Well, the Geyen family is a family I've known for many decades, and so one of their sons, one of Dorothy Geyen's sons, was someone that my wife actually used to date while they were in the singles group years ago, briefly. And so when I first got to know him, probably in the early 80s. And so I knew his mother by extension, and she worked in a local hardware store. So I would see her and say hi to her as I was coming into the hardware store.
And then they asked you to do some estate planning. Was it back in 2011?
Yes, I think that's correct. Back in 2011, the date of the Dorothy Geyen trust or trusts that are the subject of this litigation.
And what was kind of the goal of the clients at that time? Was Medicaid planning kind of on the table, or what was kind of the conversations you had, whatever you were able to share about kind of the planning goals in that case and using those irrevocable trusts?
Sure. One thing that comes to mind when you ask that question, that my practice was different back then. I did have part of my practice actual Medicaid or medical assistance planning, as it's called in Minnesota.
Okay.
Uh, and I also worked with another gentleman in that area, and we both actually attended a seminar out of state. I believe it was in Orlando, Florida, way back then, and got some initial specific training in that area. And so we did, with conjunction with him, the irrevocable trust was one tool that we did use at that time.
And can you talk a little bit about what happened preceding this case as the guy and family and Dorothy's kind of moving through long-term care needs and things like that, and kind of set the stage for what happened before she applied for Medicaid?
Sure. So I wasn't directly involved, actually, as I recall, at the time that she made the Medicaid application. Normally, we would have told our clients now, if and when it comes time for you to apply for Medicaid or medical assistance, let us know because it's important for us to help you through the application process. Well, that didn't happen for whatever reason in this family, and the Dorothy had a number of children, and so one of her daughters, who I didn't know as well, I think, did that medical assistance application process with her mother. And apparently, I'm just surmising this now because I don't think I've ever actually had a conversation with her about this, but presumably at some point in that process, they identified that, oh, it looks like you have a irrevocable trust. How much is in that trust? And she evidently disclosed that. And well, in Minnesota, I'm presuming this is the conversation. We have a statute that says uh, uh, we don't really care if it's irrevocable or not. Our statute says we consider it to be revocable and an available asset. And so you're going to need to empty that trust. And so uh, I got uh, a kind of a frantic communication from the one of the trustees of that trust, the daughter, about that time because the facility that she was in was threatening to put her out on the street unless they emptied the trust because her funds, of course, had been depleted at that point. And so she really didn't have any choice at that point. It's a crisis situation. Instead of having mom discharged from the facility and not having any place else to receive adequate care, the children, at that point, her condition was such that she needed skilled care. Her children weren't able to care for her at home, and so she really had no choice. The attorney for the care facility was threatening her, and so on and so forth, and so that's what happened. And the at that point, the process that generated this Minnesota Court of Appeals decision that's the subject of our discussion today, that process uh, began. We made an appeal to the county, Carver County, and it went on from there.
So just to be clear, the irrevocable trust, and this is in the case holding that the terms of the irrevocable trust said the trustee couldn't make any sort of distribution back to Dorothy under any circumstances. But because it was an emergency situation, what were you to do with that, with those threats ongoing? Correct?
That's correct. So the trustee was in the position of really violating the terms of the trust, so that her mother wouldn't be evicted.
What a tough conversation. It must have been a tough conversation because you're thinking kind of both things at the same time, right?
Right, exactly.
And then this statute to highlight kind of where the law was at the time that this appellate process got started. It states, and I have it here just so that folks that haven't read it yet, it states that I want to make sure I find the right section. Any irrevocable inter vivos trust or legal instrument device or arrangement similar to an irrevocable inter vivos trust created on or after July 1st, 2005, containing assets or income of an individual or an individual's spouse, including those created by a person, court, or administrative body with legal authority to act in place of, at the direction of, upon the request of, or for the behalf of the individual or the individual spouse, becomes revocable for the sole purpose of that determination. So, like you said, the statute on hand states that if you have an irrevocable trust, it's to be treated as a revocable trust.
That's
And
right.
that's kind of the world that the Minnesota practitioners trying to get their clients approved by Medicaid have been living in since, was it since 2005?
Right.
Okay. And so you have this situation where you have a client who might get thrown out, who did the proper planning under federal law, where irrevocable trusts state under 42 USC 1396P that if you have an irrevocable trust and there's no circumstances where the grantor can get those funds, then those assets should not be a accountable resource. Yet you have this state statute that says an irrevocable trust will be treated like a revocable trust. Those assets will be counted. You have a long-term care facility threatening to toss her out. The worst thing that could happen because she needs that skilled nursing home situation. They call you, you give them the advice that you need. And so you take that situation and you make an appeal, you said to the, is it an ALJ? How is the appellate structure? What was kind of the first step that you took to make that appeal?
So I believe that that was the first step. Now it's been a while since I've
Yeah.
been on that road, and so yeah, I think that was the first step, and then from there, we they upheld the decision of the MDHS, Minnesota Department of Health and Human Services, and so then our appeal was to the Carver County District Court.
Okay. And how did that go?
Well, we prevailed there,
Okay.
and as some of your listeners may know, there was another previous uh, Minnesota District Court case that also ruled in a similar fashion. Of course, it's not fully legally binding precedent, but the Carver County Court completely agreed with us, and so there was an appeal to the Minnesota Court of Appeals from that.
And that came from the agency.
Yes, the agency and the county in concert. Yeah.
Okay. And when you found out that that was being appealed, what was at that point, what was your conversations and maybe even before that, what were your conversations with the family about this appellate process, the costs associated with that, and kind of how that was all going to shake out?
Yeah. So good question. So early in the process, I made it clear to the family and particularly the trustee, the daughter trustee of this irrevocable trust, that I was not going to charge for any of my time in this whole process. I just felt that, typically back in when this was created, we would have advised our clients of the Minnesota law and said, well, this is a risk, and so and this is why we need to be involved in the MA Medicaid application process, because the question, as we know, that's asked is, well, have you given away any assets in the last 5 years? The answer would have been no. And they might have asked, do you have any trust of which you're a beneficiary? And proper answer would have been no.
Right.
Go on. So in the ordinary course of things, it might be that this never would have been an issue, but of course it did become an issue for whatever reason. So given in this particular case, given the fact that that we had drafted the trust, and given the special relationship we had with this family, I just didn't feel that the right thing to do was to charge anything for the whole process, and so we didn't.
And
So I
when,
didn't.
oh, go ahead.
And so I, of course, I no point in keeping track of my time. I have no idea how many hours I spent
That'd
from
be
start.
my next question. Okay.
But
As you were, can you kind of talk through, for those of us, myself included, who haven't done an appellate case up to this level, what was your experience with that, and what was kind of the process that you went through to get up to speed on, obviously you have to brief it, you have to go to some oral hearings as well. At this level, the state obviously have attorneys that are, this is what they do all day, every day, and that you'll be going into court with them. How do you prepare for something like that when it's not part of your kind of day-to-day legal practice?
yes, another very good question, and it brings up the fact that um, the last time I did appellate work was as a very young attorney, which was obviously a very long time ago, decades, decades since I had done any kind of upper level appellate work. Minnesota Supreme Court, Minnesota Court of Appeals. I think back when I did one or two appeals as a young attorney, I don't think there even was a Minnesota Court of Appeals, in fact. So I had no clue really on the proper. I can read the rules, of course, just as well as anybody, but in terms of the practical aspects, I really had no clue. So here's where the Minnesota NALA organization came into play. And I don't recall exactly how they discovered that I was embarked on this appellate, but they said, "Well, would you like any help?" Well,
Okay.
of course, I very much appreciate help, and so I have to say, as an introduction to this experience now that I'm going to describe is really one of the most amazing experiences I would say that I've had as an attorney, because as attorneys sometimes we get help from other attorneys in terms of pointers on this area or that, friends of who are attorneys and so on. But in terms of litigation, of course, we're in opposition, right? So here's a group of attorneys that said, well, you're involved in this appeal. We're experienced with appellate
Oh, okay.
matters, and we're particularly interested in this case, and so we would be glad to come alongside you and help you with the whole process, of which they did, which included um, they lined up somebody to help me draft the brief.
Oh,
There
good.
was an attorney who actually who drafted one section of the brief, and they would review the draft of the brief. They gave me they made sure that the brief was in exactly the correct technical format. Um,
Yeah.
and then beyond that, when it came time to the approach of the argument, oral argument before the Minnesota Court of Appeals, that they actually did a mock oral argument for me, and that was really helpful
Oh,
because
sure.
you know and I understood, I was able to learn things that I really wouldn't have been able to learn otherwise. Things like, well, what tone do you take when addressing the Court of Appeals?
What's that tone?
And so the tone is not the same tone you'd use if you were arguing before a jury.
Gotcha.
It's more sedate. It's more calm and reasoned. Okay. Um,
Thanks.
and so there wasn't going to be any kind of dramatization of the near eviction and this sort of thing. But so that was very helpful. So they were, and this group of attorneys was with me the whole way. So it was just an amazing experience to be part of a cooperative um, effort. And of course, they were volunteering their time too.
Right. Yeah, the NALA chapters in Minnesota specifically, I know are very passionate and very engaged in what's going on. And obviously, you said they're interested because this statute was a big hindrance for a lot of Minnesota Medicaid planning attorneys to do proactive planning. Obviously, if you're using or trying to use an irrevocable trust that should work under federal law and you can't use it in Minnesota, you have to use a lot of workarounds. And I know Minnesota attorneys were getting very creative in trying to do anything but just gift assets away to the kids. So I know that this was a very, very important decision for them, and that's awesome that they helped you out. And hopefully, every state NALA chapter would do that for their practitioners as well. I know as this case was going along, Dorothy passes away at some point. Um, kind of at what point did that happen, and what was your conversations with the family to keep this appeal moving even after she had passed away?
So her passing was fairly early on in the process. Once the trust was emptied and um, uh, the home was not threatening to evict her any longer. I don't remember the timing exactly, but she would have lived less than a year after that point, as I recall. So not too long.
And then with the family, kind of how I know that at that point, I know a lot of practitioners, if they have a denial, a lot of times they'll just stop, trying to appeal that decision. The client has passed away. Um, that they'll make the strategic decision that there's no use in moving this case forward. What was your kind of thoughts of let's continue this appeal?
Well, one of the reasons, maybe one of the key reasons for me to continue the appeal, there's the issue of the substantial amount that was forced out of this trust, and so I wanted to ultimately prevail so I could go after trying to retrieve that money for the family. So that was my one of my main motivations. Now, at that point in my practice, I had ceased some time prior to getting involved with this case. I had ceased for some time doing any kind of medical assistance planning. So when I embarked on this case, and particularly as I got into the district court level and the appellate level, I really was not up to speed on current cases in this area of the law. And so this again was where Minnesota NALA was extremely helpful. And I got a education or re-education along the way in this area.
And so as you're moving forward, you're about ready to go into oral arguments. Kind of what are you thinking going into that room, and what were you hoping to accomplish during those oral arguments? Again, as someone who's never been to that level of court appellate work. What's kind of the thoughts that are going through your mind as you're going in? Are you trying to anticipate what questions they're going to ask? You want to be ready? Are you nervous? How what's that feeling like as you're going into that courtroom?
Sure. So yes, you're aware that as arguing uh, arguing a case before the appellate court, you've got your argument all laid out in succinct fashion, but you're also aware that you may not get too far before you start getting peppered with questions. That's how it is. And so you have to be ready for the questions, ideally anticipate the questions that will be asked, and be able to pivot quickly to address those questions, and then try to get back to the thread of your oral argument,
Right.
your presentation. And so, yeah.
In this case, from my reading of it, and you might have a different reading of it, kind of stood on three different pillars: the standing issue, whether or not this trust allowed um, Dorothy to benefit from it, and then whether or not the state statute was compliant with federal law. Were those kind of the three areas that you had worked on the most, or were you ready for those, or was it was there anything that kind of came out of the blue at you that you hadn't really been prepared for?
No, I think I was pretty prepared for pretty much anything that would and did come before me in that. Again, partly thanks to Minnesota NELA, but my as an attorney, I guess my right from the start when I had my first jury trial, I was prepared to the max. So um, that's always been part of um, my mode of operation. So I don't think there was any question that I can recall that caught me off guard. It was very interesting to be part of this real time with
Yeah.
the court also peppering opposing counsel with questions, and very pointed questions, and some that he had difficulty answering, which because um, his employer, the state of Minnesota, had him in a difficult position. I mean, he's um, arguing for the validity of a statute that's clearly invalid and contrary to federal law. So I
When
didn't
you
have
yeah
I
when
didn't
you
see his
oh,
position.
yeah I wouldn't either. When you walked out, how are you feeling? Were you feeling that you did well? I know a lot of times you'll walk out of a test. It's been a while for me since I've taken a bar exam, but you walk out, you're always thinking about, oh, I should have said this, I should have said that. Was there any of that going on, or were you feeling like pretty confident that you were going to overcome this appeal?
I recall feeling pretty confident about it, and I conversed with the Minnesota NALA people that were a lot of them were watching
Oh, okay.
too, and it was at that point by Zoom.
Okay.
Uh, so there were a number of them that were watching that Zoom argument, and then connected with them briefly after, and they thought it went very well as also.
And then
So
what was kind of the timeline before you got the decision back?
I don't really remember right now, but it was fairly timely. I it would have been pretty timely. I didn't have to wait too long. It might have been it could have still been a month. So,
Okay, that's pretty quick. And then once you got that decision back, um, kind of how did that impact your clients and where are things now, I guess? What was the end result of getting this decision?
yeah. Well, so now began the practical aspects of this, and that is okay. That's all great, but now where's the money? That's
Right.
how do we get the money? And so now we have to pursue a claim against, and we're just about to embark on this process now, but to bring a claim in Carver County District Court, and against both the Carver County and the care facility. By the law, unfortunately, doesn't allow us to make a claim against against Minnesota DHS, the state of Minnesota directly. So, with regard to the recourse against the state, really the only recourse there is to and this is something else I was coached on and had never hardly ever heard of this, but there's such things, and I think this is probably the case in every state, but there's such things as the authorization of a claims bill. And in Minnesota, for example, there's a statute that allows one to submit such a claim for consideration before the Minnesota State Legislature, and it's specifically for areas like this where there isn't any other valid legal recourse against the state of Minnesota, and yet the state has harmed somebody in some fashion. And so there's a claims committee in the legislature that considers the claims bill, and it may get approved, it may not, and of course there's no recourse if it doesn't get approved.
Huh.
So yep. So I didn't either. So that's one avenue we're in the process of pursuing, and then the other one is this district court claim against the county and the care facility, and really we haven't finished crafting that complaint yet, but the primary basis of that will have to be just equity. Of course, we know our district courts across the United States are courts of equity or fairness, and so courts have these equitable powers, and it doesn't have to fit with within any other kind of legal rubric necessarily, but the courts can decide, well, as a matter of equity, and this would be my argument to the court in our briefing or oral argument again. This is a classic case of equity. Here you have the state of Minnesota and the county and the nursing home using this invalid state law in the most inequitable fashion possible. I think we're going to use this law to force you to empty out this trust that's completely valid under federal law, and otherwise, and we're going to deny you medical assistance, and so if you don't empty out the trust, then your mother's out on the street. And the district court judge that upheld our argument, that was later appealed, was totally cognizant of the picture, the graphics of the whole thing. And so we're hoping that the next judge that sees this at the district court level will be as well. Of course, it'd be great to get the same judge.
Yeah, wouldn't it?
That.
Already understand this case. Do you know what has happened with the statute now that the court has come down and said this is an improper statute? And I know you said you're not doing much, MA planning now, but do you know if practitioners have started to use irrevocable trust, if those are getting challenged, or if the statute has been repealed, or what kind of happens when the court says the statute is invalid and it's still in the books, obviously?
Right. Well, I'm not sure. To my knowledge, that nothing has happened with the statute. It's still on the books, and I've talked to different practitioners about how this affects practical Medicaid or medical assistance planning now, and I've had some say, well, I think we can use irrevocable trusts without fear of what happened in the Geyen case, so long as we make sure that they're compliant with federal law. Other practitioners, I think, are more cautious and say, well, I'm not sure. I still think I'd stay away from them. So I think my impression is that there's some divergence of opinion there.
That makes sense. What would you say was the most important lesson that you kind of learned from going through this experience?
Uh, that's a good question. I may need to think about that. The most important lesson that I learned from the experience. Well, the first off, I'm not sure if I'd call it a lesson, but as I mentioned, it was a very gratifying, extremely gratifying experience to have to be in this position where I've had these other attorneys come alongside me without charge to assist with this kind of a case. So it's a lesson that I think that cooperation can be just as gratifying and maybe more gratifying than just drilling somebody into the ground legally through prevailing in a case, right? So even though at this point in my practice I don't actively pursue litigation cases either. So
That's a good lesson, I think. I think it's a lot of reasons people have learned that lesson, and that's why they try to practice in elder law and estate planning, much like you're doing now. Is there any advice you would give attorneys that get an adverse Medicaid decision from the agency, maybe take it up to that, the next level, the fair hearing level, and are denied and are weighing whether or not they should continue the appellate process? Is there anything you learned from that interaction with your clients, or the process itself? Because I know a lot of attorneys get to that point, and that's kind of the make or break decision point. Are you going to take it up to the court level, or just um, take the result from the ALJ and move on?
well, unfortunately, I think the biggest determinant in this is the cost.
Right.
In this case, of course, the cost wasn't a factor, but when I used to do medical assistance planning seminars, Medicaid planning seminars, we talked about this very statute, and we mentioned that well, it hasn't been challenged yet. Someday somebody's going to challenge it. Not it's going to be me, but little did I know. But I think as a practical matter, in a lot of cases, you've got families, of course, who are mom or dad. Let's say they're getting to the point where they need to apply for medical assistance because their assets are depleted,
Right.
and so the parent, the person that's applying for medical assistance, they don't have the resources to pay an attorney to fight on this much, and the children may not, the next generation may not have too much incentive either. Depends on I guess, on the unique facts of the matter, um, but I think that's the biggest practical consideration, is that, well, a lot of times there just isn't a choice. As a practical matter, appealing is too expensive. Now, I don't think the lower level appeals are that time consuming,
Okay.
or would have been that expensive for the Geyen family. Um, the, um, for example, when it got to the district court level, it was really just submitted to the court on stipulated facts.
Okay.
Typically, the facts are not in dispute, And so it was not very time consuming, and therefore wouldn't have been very costly if there was a attorney charging for their time up to that level. I think once you get beyond that level to the appellate, state appellate level, now it's a different story. I mean, now you're it's a lot more time consuming, the whole process. And for an attorney who's conversant in the area, it probably isn't that time consuming and therefore costly for their client at the lower levels, because they're very typically very familiar with the laws and um, uh, the other legal precedent that has to go in the medical assistance planning manual and so on. Um, they're very conversant with that, so there's not a lot of research that has to be done at that point.
I would assume that it gets real expensive when you start hitting the appellate level with the different procedures and, like you said, how to write it in the right format, how to make sure that you're addressing everything, and then obviously the time spent to prepare for an oral argument is really where the time can add up.
Right, exactly. Yeah.
Well, John, thank you so much for agreeing to chat with me and kind of playing it forward. Those attorneys that kind of helped you. I think this insight that you're providing on a really landmark case in the areas of elder law planning, really in Minnesota, but I think it also gives an example for any attorney around the country that is dealing with a policy or a administrative rule, or at this point a statute that violates federal code, of what you did to kind of overcome that and what you went through. So I really appreciate kind of pulling back the curtain, spending some time with me today, and sharing your experience, and hopefully others find it really helpful and as interesting as I think it is. So thank you so much, John.
Yep, you're welcome. My pleasure.